The order regarding termination or modification of a guardian of an individual with a developmental disability. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover scale form PC638B as reflected in the little yellow arrow in the bottom left corner. This particular form is a form for the use in an order for a developmental disabled individual, not to be confused with a guardianship of an adult of a legally incapacitated individual or of a guardian of a minor. That is a separate form. This form is used in the mental health code when somebody has been diagnosed with a developmental disability. The court rules and statutes that give rise to the creation of this form are also reflected in the bottom left corner. Those court rules are defined under the mental health code rather than EPIC, E-P-I-C, the Estates and Protected Individual Code, which reflects the general guardianship statutes. So remember, this is a court order, not to be confused also with a petition. A petition is the request of the court, and the order is the ruling and determination of the court following a hearing on a petition for the appointment, modification, or termination of a guardian of a person with a developmental disability. Let's work our way through the form. In the top left corner, there is a space for the county. In the top right corner is a space for the case number and the judge. The top part identifies the court address, and then in the matter of is the estate name. So this would be the individual that the court is making a ruling on relating to the modification or termination of an individual that is having a developmental disability in need of a guardian. Section 1 identifies that notice has been provided. There's a particular court rule and statute that identify how notice is provided by virtue of a petition for a modification or termination of a guardian of an individual with a developmental disability. Section B identifies whether the request was to terminate, which means to end it, or to modify it, which would be to change it in some way. So for example, if you're modifying who the guardian is or the powers within that guardianship, that would be the reference in paragraph 2. In addition, there's a provision that allows for the court to make on its own motion, on its own request, rather than the request of a petitioner, that a guardianship may be terminated or modified. Section 3 identifies whether the guardian should be removed and a successor appointed. There's a resignation opportunity in the second checkbox. And then third, that the guardian may have died or become so disabled such that they could no longer manage the guardianship. Number 4 identifies whether that individual continues to need a guardian, as well as whether there's no longer a need or there's a need for a standby guardian under the developmental disability rules. Now, number 5, it identifies that there's no suitable person to serve. So this would be a circumstance where there's no family member or loved one to provide the guardianship related services. So the court is going to identify and select a professional guardian or agency to serve based on the best interests of the individual. In those cases, a bond has to be filed. That's a surety bond. The second portion identifies the court's order. So the top part are the findings of the court. The bottom section of this particular form are the court orders. And it's really a repeat of what we saw above. The court is identifying whether somebody is removed or permitted to resign, whether the person is required to do an accounting for purposes of handling any of the financial affairs of the individual, whether the person has been discharged, and whether this matter remains open or it's closed. In addition, it identifies a space for the identification of a successor, that means a new person to serve in the guardian, and then what requirements are necessary for them to qualify. On the back side of the document, it's a continuation. It allows for the appointment of a standby guardian or a successor standby guardian, and that allows that person to step into the role in the event of death or incapacity or a resignation. The idea being that if the guardian of this vulnerable person dies or becomes incapacitated, the standby can immediately step into the role rather than having to go through a long drawn-out court proceeding. The next part identifies that the standby guardian has to, again, qualify in the role. They don't just simply swoop in, but they have to qualify as set forth within the court order. In the bottom section, it gives a space in the event that the court is entering an order modifying the the guardian's powers. That section under 9 can be checked, and it gives room for the court to identify the modifications of those powers. In addition, there's a provision that identifies that the guardian can do an application to admit the individual if those circumstances are appropriate. It also gives a very kind of clear 3 checkboxes in 8 whether the petition is granted, denied on the merits, or dismissed or withdrawn. And then kind of a catch-all paragraph so that the court can fill in additional information. In the bottom section here is a space for the judge to sign, and then of course, if there's an attorney of record, for the attorney's information to be placed there. Now these types of matters are confusing. They're not intuitive, they're not easy to navigate through, so we strongly urge you to work with a skilled, competent probate lawyer to guide you through the process. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular order or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.